According to the Western scholars, international law is a product of Christian civilization that gradually grew in the second half of Middle Ages. But when we go through the text of Ramayana and Mahabharata, we find that the allegation of the Western scholars that international law is a product of Christian civilization is not true, because certain important principles of international law, such as diplomatic agent and asylum, find their mention in the text of Ramayana and Mahabharata. But we can say the international law we read today is a product of modern European state system, which grew or we can say which came into existence after conflict with feudalism and church. As we all know, international law is a dynamic law. It has been changing since its origin. Till the second half of the 20th century, the character of international law was individualistic. It was only after the Second World War that the character of international law changed to law of social interdependence. In individualistic characteristic, international law used to deal with mainly trade. The main aim of international law was to facilitate trade, though it dealt with other important issues such as boundary, river, but main focus was to facilitate trade. It was only after the Second World War that the character changed to social interdependence, in which where the horizon of international law changed manifold. Now international law deals with important issues such as maintenance of peace, space, environment, human rights, etc. And this scope goes on increasing. Today, international law is also dealing with important issues of copyright and intellectual property rights also. Interdependence of one nation on other is the need of hour. Today, no nation can survive on its own, considering the expansion of science, technology, trade, commerce, etc. So we can say the growth of international law mainly depends upon the growth of science, technology, and other things. There are certain factors that have contributed to the development of international law in the last two centuries. That can be summarized as first, international organization. Second, individual. Third, codification of information. So first of all, we discuss international organization, how international organization have contributed to the development of international. In the 20th century, international organization of universal character came into existence, such as United Nations, World Health Organization, World Bank, etc. These international organizations contributed hugely towards the development of international law in their different spheres. It is only because of these international organizations that international law today is dealing with vital, important topics such as human rights, dealing with nuclear weapon, health, trade, commerce in an efficient manner. Second, individual. As we have seen in our last class in the discussion of definition, that prior to the 20th century, the international law was only limited to the state, or the definition that came the scholar, or the definition that were given by the scholars only included state. But in the 20th century, individual and international law, international organizations were regarded as a subject of international law. And the definition that came after the Second World War included international organization and individual as a subject of international law. Today, the main focus of international law is towards individual by protecting his human rights and other. And even there are many international forums that allow individual to bring petition on his own. Third factor that have contributed towards the development of international law is codification of international law. The rules which were ambiguous, which were not certain, were codified, were written and made certain in the 20th century. This was mainly done through formation of treaty. At regional level, at universal level. The first instance where international law was codified through treaty was the Congress of Vienna, where certain important principles of diplomatic agents were settled, or rules relating to diplomatic agents were made